Can I ask, because there are some people that might be disappearing, and it's so incredibly helpful for our building up, the feedback we got from the last one has helped build this one. So if you have an opportunity, there's 3 quick questions. If you wouldn't mind clicking on the QR code, that would be fantastic. But in the meantime, there are 3 questions on the chat that I'd quite like to pick up. And the first one came in from Catherine Quinn. Catherine, you've used the term AWI form, and you may not have heard the Commission going on about we don't use AWI. We like to have that defined a little bit more, like you would define a short-term detention or an EDC or a CCTO. So I'm assuming that at that point you're talking about a Section 47 certificate. So absolutely, until the guardianship's in play, you would want to make sure that it was in place. There was an up-to-date 47, and there was the appropriate treatment plan indicating where there's capacity and incapacity for whatever treatments that you're intending to give in relation to medical care. The next question came in from Carol White. And Carol, yes, while a person has capacity, the welfare powers of a power of attorney cannot be activated. That individual still can make decisions, as Mary's already alluded to. We encourage wherever possible to make sure that people are involved in the decision-making process, and its decisions are specific to the circumstances they give. But actually, someone that still has full capacity would not have active powers or the welfare powers activated in that power of attorney. But you're right, the financial powers start from the minute the power of attorney is lodged with the Office of the Public Guardian. And the final question that, again, I'll have a little bit of a hobby horse on from is around, let me find it here, I'm whizzing by, it's from Ashley Jarrett, and you've done the same. You've got AWI as a generic term, so I'm making the same assumption that what you're referring to there is a Section 47. And yes, there may be a power of attorney, and you may have the documentation and it may have specific powers, but we would still, from the Commission's perspective, advise that a Section 47 certificate is put in place to cover them. It might be that you mean something different from AWI, and if you do, please pop back onto the chat and we will happily pick up some of the questions. We have one specifically from Catherine Quinn, and Mary's going to do that, so we'll all come back together on this one and pick through. There's a couple of questions that have come up to do with your presentation, so if you want to join us, that would be lovely. Thank you, and I'll hand over to Mary for Catherine's question.
That was the question in relation to moving to a care home. Yeah, I've got it. So remove somebody who cannot consent to a move themselves. So somebody who lacks capacity, there needs to be a legal authority to authorise their move into a care home and out of hospital. Now that can be done under 13 ZE of, I can't remember the name of the Blooming Act, it's a Social Work Act. 13 ZE does authorise the movement of somebody to a care home who lacks capacity, provided everyone's in agreement about that move and the adult is not objecting or resisting the move in any way. However, once a guardianship application has been lodged with the court, then you cannot use 13 ZE, and you do then have to wait until the guardianship powers to authorise that move have been granted. So hopefully that's helpful.
Okay, thank you. I'm going to come back to the next one, which is the question from Sarah. Sarah, again, hopefully we've got the kind of tenets of your questions you ask. I think it's probably quite difficult to kind of frame them. Your question was about the use of medication for sex drive, to reduce sex drive, on a T2 or a T3. You would only be using T2s or T3s, presumably if the individual is detained under the Mental Health Act. If they're there informally, then they're presumably agreeing to take medication that does that. The other part that you ask about, would these be required in community also? And we're making the assumption that at that point it's varied, the compulsory treatment order has been varied to the community. So they would be in a CCTO, so as Leslie said, that would carry through. So they would still remain on T2, T3s, whatever one was being used in terms of the medication. T2 obviously if they're consenting, T3 if they're not. The other question came in from Ramesh, and I hope I've said that right. Ramesh, your question is around about how would we feel about a depot injection being recorded in a T4. I think you can pretty much guarantee that the Mental Welfare Commission would not be happy to see a depot injection being on a T4. We would expect that, and particularly out with the 2 months, at that point we would be concerned about the lawfulness of the treatment that had been given. Could this be justified as urgent treatment? I'm not sure depots would be considered as urgent treatment because it's a long-term acting solution in preventing deterioration. It comes back to what Leslie was saying, that you're kind of covering all bases with that. So at that point, we would be urging you to get an urgent DMP assessment done or an urgent DMP out to see you, and then get the proper treatment authorised on the proper forum. We've got another few questions here, and I'll maybe, Leslie, if you've been checking in on them, or are there any of them that you picked up at that you want to, and then Mary and I'll keep an eye on them as they come through.
There's one here from Kim Barron. Does the Commission have a view on EMPs who can assess and put in place Section 47s and put in place covert medication pathways? That's absolutely fine, provided it's a suitably qualified person, providing you can demonstrate that you've got the skills and you've had the training to certify incapacity, then it doesn't need to be a medical member of staff. And again, the put in place covert medication pathways, again, I assume it would be a team approach with regards to that as well. So yeah, it doesn't need to be an RMO who puts, or a doctor who does a Section 47 certificate.
And I can see that a question has come in. Can a Section 47 authorise prescription and administration of antipsychotic medication without an order under the Mental Health Act? If the adult lacks capacity, then they can be treated for both physical disorder and mental disorder under the Adults with Incapacity Act. And therefore, yes, antipsychotic medication can be prescribed on a Section 47 certificate if the adult lacks capacity. So, yeah.
Thank you. And Lindsay Young, thank you for that. The reminder of the Social Work Scotland Act 1968. I'm not sure we would have got that. Catherine, you've come back. The question is specific to the patient who declines moves to the care home. I think sometimes it would be useful if you've got scenarios, I think I said this at the start, by all means, email us in, bring it through to inquiries. We'll be very happy to pick it up and get back to you directly from that perspective, if it's something that probably requires a more honed answer than what we can offer today. Alison, you've got a question here. If treatment is authorised in a T2 or a T3 is above the BNF max dose, should this be specified on the certificate, i.e. lorazepam 8 milligrams or promethazine up to 200 milligrams? I think if they're authorising, if it's documented in terms of how the conversation's gone, the DMP, as Leslie said, that whole conversation in terms of what is authorised on the T2 or the T3 will be considered by the DMP through that process. So if they think there is a requirement for it, then they would know whether it was off licence or out with, but they would also need to know any of the sort of clarity or tests or parts that were being done, like we would do with clozapine when we have to have a blood monitoring that goes with that. So that, as Leslie I think beautifully put it, falls within the domain of the DMP as they're reviewing the records, as they're checking that. But equally with the RMO, if it's a T2 and they've had the conversation with the patient who's presumably signed and in agreement with using drugs that are out with the range that they should probably be prescribed at. But you would expect treatments and the safeguards around about it in terms of physical health monitoring to be in place too. All righty, Leslie, is there okay? All questions and answers are coming up, and I think is that Sally. If you detain a patient with a mental disorder who requires treatment for physical condition, if they're recusing them, Sally, you might need to put that one back in again. I think we're struggling to get the information they want. But as I said, there's the advice line and the inquiries. Phone us. We're here Monday to Friday, 9 till 4, with a wee break for lunchtime. So if there's anything else, some new messages. Okay.
I'm looking at the one by
William
William Beard. So somebody's resident within a care home, there's a section 47 from the GP. Local authority or guardians must care home staff request local authority to authorise a vaccination or dental treatment. Two things. A lot of local authorities, when they take out guardianship, deliberately do not take out full health powers, because they say that they don't know the person well enough, and that the doctor, if they don't have health powers, then the section 47 would authorise medical treatment that the doctor feels is necessary. So in a lot of cases, you always have to look at what the actual powers are. So look at local authority guardianship. A lot of them will not have medical powers associated, so therefore you don't have to ask. If they do have medical powers associated, yes, you do have to ask. And one other thing, when a local authority is a guardian, that means the chief social work officer is the guardian. That's the person responsible. When you are making decisions on somebody's behalf, when you're taking away their liberty and making decisions on their behalf, there is a requirement for reciprocity. So you then have to have somebody, a named individual, who is responsible for those decisions, not just the local authority as an organisation. That responsibility sits with the chief social work officer. He can delegate that to a social worker. So there should be a named social worker who you'd be contacting to get that authorisation if the local authority has got a guardianship with powers to consent. And that's something I've got to be in my bonnet about. I hate getting into a guardianship visit and find there's a local authority guardian, and when you look to see who's to be contacted, it says duty social worker. That's not acceptable. I've got off my soapbox.
There we are. Thank you. Oh, were you just testing us there, William? Thank you for that. Leslie, are you happy to pick up Lorraine's query about eat disorders, NG tubes, and requiring under strain, T2s and T3s? Over to you, Leslie, if that's all right.
It's likely. So if the NG tube's already in place, I take it you're asking. If it's already in place for feeding, and then you're talking about putting medications down, that I'm not sure what you're getting at. Maybe put a further comment. I see you've said yes. So if it's in place already and it's required to be in place for that, you shouldn't be putting it down purely to facilitate giving medication. But if it's already in place at the time, then yes, it's okay to use it as long as it's required to be in place for the physical treatment that's been given. But you shouldn't be passing NG tubes purely for the purpose of administering medication. Does that answer your question?
That's a yes, Leslie.
Okay. If there's anything further, Lorraine, just put a wee question if I've not quite understood that. But certainly that's yeah, absolutely. There's no harm using that as a route if it's currently in place, but we shouldn't be passing NG tubes and keeping it in place longer than is required for the treatment of the physical health purely to allow us to put medication down it. It's only if it's in place and it's required to be in place we can use it.
Thank you, and thank you to all of you for joining this afternoon. It's been a pleasure having the conversations as easy as you can on a webinar chat. Can I just again ask if you would pop back in and give us some feedback? It's, as I've said, it's incredibly helpful and it keeps us focused on what we need to